his testimony, Dr. Cooperman also acknowledged that in a previous interview with the Jinx producer on February 17, 2012, that he said the caller sounded like Kathy. You don't say it sounds like somebody unless you know what their voice is. He said it sounded like Kathy.
Okay, so this is where the defense is really putting a lot of focus. If this one fact falls for the prosecution, does the whole case come tumbling down? Let's bring in Court TV legal correspondent Stanley Ford. Join us live tonight from Los Angeles County, California. Stanley, great to see you. We got a big week in store here in this case, but let's start with all of this. Give us a little more context around this call and how prosecutors attempted to prove to this jury that Susan Berman made the call, that Susan Berman was the key to unraveling the Kathy Durst case against Robert Durst.
Who else could have made the call? The prosecution spent more than 2.5 hours on Kathy Durst and her disappearance during the closing arguments for the prosecution. That's why David Chesnoff in the defense close was focusing so much on trying to counteract that big piece of evidence for several different reasons. Because if this jury believes that Susan Berman helped Robert Durst cover up the disappearance of Kathy Durst in 1982, then that would make her a witness to that crime, which would up the sentence if convicted of the first-degree murder here of Susan Berman. So that is why they focus so much on that key piece of evidence. And for the prosecution, they have Susan Berman's own words. She told multiple people that she helped her friend Bobby Durst cover up. She was his alibi, that she made that call to the medical school February 1st, 1982, pretending to be Kathy Durst, calling in sick. And the prosecution went to great painstaking detail to put through witnesses and, of course, stipulations about fellow classmates and medical school students who say that that would not have been proper protocol for Kathy Durst to call a dean of the school and not the person in charge of her rotation she was supposed to begin that morning. So a lot of evidence for the prosecution here. And again, the defense trying to turn that narrative around to say that there's no way actually Susan Berman was the one that made the call, because we have Dean Cooperman, and for decades he maintained it was Kathy Durst who called him that morning.
This is, it's an important part of the case. And the bottom line is if she doesn't make that call, then the argument is, right, that, all right, she didn't make the call, she didn't help cover up, there's no reason to kill her. And by the way, Robert Durst had nothing to do with the death of Kathy Durst, or the disappearance of Kathy Durst at this point. It's a fascinating way. I mean, how much, if you had to gauge from listening to the whole closing argument, how much weight did they put on this one aspect of the prosecution case versus, poking holes or trying to do things to other parts of the prosecution case?
Well, the defense, we kind of tried to break down the timing of the prosecution close and the defense close and how much time they focused on Susan Berman, Morris Black, as well as Kathy Durst. Here, the defense spending about an hour and 11 minutes on Kathy Durst in that phone call, about 27 minutes for Susan Berman, Morris Black, 32 minutes. But the prosecution, Vinny, spent a bulk of its time, 2.5 hours on Kathy Durst's disappearance, and about 2 hours, 12 minutes on Susan Berman, Morris Black, an hour and 12 minutes. So I think that really shows that the weight of the evidence for both prosecution and the defense, the bulk of the time focused on that woman there, Kathy Durst, because that is the genesis of it all, the disappearance of Robert Durst's wife, and according to the prosecution, everything he's done since that time to cover his tracks and evade responsibility. And key players for that, according to the prosecution, Susan Berman and, of course, Morris Black, when he found out who Robert Durst was.
Okay, stand by, Stanley. Let's bring in the think tank tonight, get some reaction. Joining us in Fort Lauderdale, Florida, criminal defense attorney, civil rights attorney Kecia Early. In Philadelphia, Pennsylvania, family law attorney Jennifer Brandt. And in Atlanta, Georgia, criminal defense attorney Michael Bixon. Good evening to everyone. Kecia, okay, this is a big part of the attack by the defense. Is that at all risky if the jury is thinking like, well, that's it? All right, so you're attacking that, but I believe that based upon the evidence that she did make the call, therefore he's guilty. I mean, can this be dangerous for the defense that it comes down to that factor and that factor if the jury believes the prosecution that it's game over here?
Not at all risky. It's necessary. It is the defense job to point out what the prosecution did not do. And in this case, it was absolutely necessary to point out that it was, in fact, the professor or the dean who confirmed that it was Susan Berman. So if, Kathy Durst. So if it wasn't Kathy Durst that made that call, then that obliterates the entire prosecution's theory of whether or not Mr. Robert Durst was, in fact, guilty. So I believe that you say that this is the murder jinx trial. This will definitely be the jinx acquittal, because I see that Robert Durst will be acquitted of these charges.
Okay. We have this on, we record the show every night, you know, Casey. We record it so we can play it back next time you're on,
Play
just
it back.
in case.
Play it back.
All right, you may be right. I never know what these 12 people are going to do. I learned that a long time ago. Jennifer Brandt, okay. Are you at all concerned that the prosecution spent so much time on Kathy Durst when this is the murder trial for Susan Berman?
No, I think they did the right thing. And I disagree with Cassia, because I think that Robert Durst is going to be convicted. And I think that the prosecution did a very good job of showing, first you have to establish why Kathy Durst was missing and what happened to her and how Susan Berman's linked. And I think they did. They spent a lot of time on that. And I think they did a pretty good job of showing that. And then there's a reason, a motive for Robert Durst to kill Susan Berman. So if you don't establish the Kathy Durst incident first, then I don't think, then it's true. The rest of it sort of falls apart. And I don't think the dean, one person, is that reliable when he's recognizing a voice over the phone. I don't think that's going to carry the day in saying that it was Kathy Durst that called. So I think the defense did the best that they could, but it's not going to be good enough. That's my prediction.
Michael, what's the jury going to do with this? Is the jury going to debate? You think they're going to debate who's making this call, and they'll spend a lot of time inside that jury room? Because they focus on the call, then they're not focusing on the murder of Susan Berman.
I do. I think that they're going to spend a lot of time on it. I mean, it makes sense to focus on the motive behind this entire series of, alleged series of murders, right? Now, does the state need a motive? No. I mean, the jury could convict him without one, but I do think that, reasonably for a jury to convict him, they're going to want to know why would he want to do this? I mean, ultimately, if they just don't believe anything that he said on the stand, sure, they could absolutely still convict him. But I do think that a motive is going to go a very long way in helping the state's case.
Okay, I want to play a little bit because John Lewin, he's been sitting there and he's been waiting. He made a lot of objections. He exploded at the end of last week, but he got up finally with his opportunity to give his rebuttal closing argument. He started that today. Let's take a listen.
This is about as simple a case as you'll ever find. There is, by the way, there is no time limit that you have as jurors. You could go back in that jury room, and it would certainly be reasonable for you to go, okay, prosecution's put on what amounts to about 4 confessions. Bob Durst is finding the body. He's setting the cadaver note. He's got Susan Berman breathing on him when she's dead. He's got garbage about staycations and marijuana pot growers and industrial-sized tampons. I mean, some of the stuff that he came up with, it was just awe-inspiring. You sit there going, oh my gosh, where does he even come up with this from? You could go back there, and it would be completely reasonable for you to go, okay, what did the prosecution put on? They put on, if all you had, they put on Bob Durst admitting that he found the body. And previously to admitting he found the body, we have a cadaver note. A note that before he admitted he wrote, he said, quote, a note only the killer could have written. If all you had in this case was Bob Durst's original denials that he had found Susan Berman's body, but you had the cadaver note that he admitted to writing, you would be within your authority as jurors to say, you know what, there is not a reasonable interpretation as to how Bob Durst would have been in California, in Los Angeles, for no reason when he said he was never here, how he would have gone to her house, found Susan dead, and not called the police if he weren't her killer. That's before we even talk about Kathy or Morris or anything else. So just because this case is lengthy doesn't mean when you go back into that deliberation room that you have any obligation to go, okay, let's look through every piece of evidence. You are well within your discretion, if you so choose, to go back and say, okay, we've heard the evidence. Is there anybody here who doesn't think that the prosecution's proven this case beyond a reasonable doubt? And if that's where you are, and that's what the evidence dictates, that's it. This is not complicated. The defense wants this to be complicated. They want it to be involved. They want it to be controversial. It isn't. It is very basic.
KC, I was watching you as you're listening to that. Where are you buying what John Lewin is selling, which this is a very simple 5-month trial?
He goes from it's simple, it's not complicated, and then he complicates the entire case. He had a case in the beginning, and I'm just listening to his closing arguments, and I always say, take me to closing, and I'll take you to an acquittal as a defense attorney. But I believe he lost the jury. Focusing on Morris Black. If I'm a juror, I'm going back there in deliberation and saying, let's put aside Morris Black because he was acquitted. You're telling me to follow the rule of law, and then you're bringing up Morris Black to show this propensity of violence, this propensity for him to commit these crimes. He just convoluted this entire case. He lost the jury. He lost the trial. I'll say it again, not guilty.
Jennifer Brandt, he's looking not only for a guilty verdict, but he wants a fast guilty verdict.
Well, and I think he did the jury a favor, actually, because he's trying to make it very simple for them. He's saying, look, it's not all that complicated. Don't spend all the time going through all this evidence. Just look at this guy. He's guilty. I mean, he's just trying to make it as simple as possible. And I think it's somewhat helpful for the jury. You don't have to go through everything. You can just decide right away, do we think he's guilty or not? And just break it down that way. So in some ways, I think he's trying to do the jury a favor. So
All
I
right.
still disagree with Castillo.
Let's check back in with Chanley Painter. Chanley, John Lewin's looking for the super fast verdict. That was amazing. I've never seen that move that direct to a jury. Like, I've seen people argue, like me, it's a simple case, but then saying, listen, you can find him guilty. You can go in there, you can vote, and we can be out of here, folks. All right, so what is in store for tomorrow? When does the jury get the case? When are we in verdict watch? All of that.
Well, Prosecutor Lewin will resume his rebuttal close promptly in the morning, 9 a.m. Pacific. That's noon Eastern. He will have until the lunch break here, Vinny, to close his case out because that's when the judge says this jury must begin deliberations. They will deliberate along the same schedule as the court schedule. So until about 4:30, 7:30 Eastern every day deliberating. Court is dark on Thursday, so they do have Friday, though, as an option to continue deliberations if they don't have a verdict by tomorrow or Wednesday, Vinny.
All right. Well, we'll see if they listen to the prosecutor. I mean, we could be talking about a verdict 24 hours from now. If they listen to John Lewin. All right. Chanley Painter in Los Angeles. Big week, folks. Thanks so much. When we come back, we're going to take you to the other coast, Brooklyn, New York, federal court. R. Kelly, R&B superstar. Day 15 of that trial. One of the backup dancers testifying against R. Kelly. We'll tell you what she had to say when we come back. Day 15 inside the courtroom in the case against R&B superstar R. Kelly. It's federal court, so there are no cameras, but we do have these sketches. But we've got more than just sketches, folks. We've got Court TV legal correspondent Julia Janae, who's joining us live tonight from Brooklyn, New York. Julia, great to see you. Let's begin with the backup dancer, Angela, testifying today. What did she have to say, and how powerful was this testimony?
Vinny, her testimony was one that reverberated through the courtroom once she was done, through the courthouse. You could see people running as far as media wanting to make sure they got the information out that she testified about on the stand, because it really went to a pain point in this entire case and the prosecution of this defendant. Now, Angela went by just her first name. She wanted to be anonymous as far as her last name. She's someone who was on tour with the defendant, and she testified that she actually met him when she was only 14 years old, that she went to his apartment and he put her in a group of other girls to be a singing group to go on tour with him. She said that she started having sexual intercourse with him early on in that relationship, that sexual relationship continued until she was between the ages of 16 and 17. That's actually when it waned, she said. And he also said, or she said rather, that he introduced her to the R&B singer Aaliyah when she was 12 years old at the time, and that there was an occasion later from that she walked in on Kelly performing oral sex on Aaliyah. She testified that that was between 1992 or 1993. She wasn't very specific about the year, but doing the math, that would have made Aaliyah between the ages of 12 and 14 at that time. So we're seeing something of what things were like inside the musical world of this defendant when he was first starting or rising to fame. We know Aaliyah was his protege, that she was someone who was working on albums with him, and we've always heard rumors and things that were never confirmed when it comes to their relationship. But we know about the marriage. That is part of this case and prosecution against him as far as a bribery charge. But hearing today that this woman, a girl at the time, walked in when she thought she was playing a prank on the boys who were in their group, and says that she witnessed this and saw it, and just something that goes to the overlying case against this defendant, because he would have been in his mid to late 20s at the time of that incident.
Absolutely shocking testimony. Let's bring the think tank. Julia, we'll get back to you in just a second. Kezia Early, Jennifer Brandt, Michael Bixon still with us. Michael Bixon, how devastating is this testimony tonight?
Well, I mean, I don't think there's a question that, it helps. I mean, obviously it hurts the case for the defense. The question is how much, and I think a big portion of that comes down to how reliable it is, how much the jury is actually going to believe it. That's obviously up in the air. But when you get somebody that's, I think, credible, that comes in and makes testimony like this, yeah, obviously it is damning and it does hurt his case.
Jennifer Brandt, this to me is gets to the heart of what prosecutors are alleging R. Kelly is all about. You've got a young, I'm going to say woman. She's not a woman yet. She's a girl, and then a teenager, and then another. Aaliyah's just a girl when she meets R. Kelly, 12 years old, and early on in that relationship, this alleged act takes place that is witnessed accidentally by this witness. Jennifer?
Well, I think it's very damaging testimony and very disturbing, and I think this witness sounds to be very credible. I mean, she was young at the time, that's true, but I mean, obviously what she saw stayed with her. It was something shocking to her, and walking in and catching this, it seems very real, what we're hearing, and I think it goes a long way in helping the prosecution in this case against R. Kelly. It's just, as you said, it kind of fits in with everything that we're hearing about him and his propensity for young girls.
Kezia, the allegation is he's running a criminal enterprise to accomplish just what is being alleged by this witness.
Yeah, I agree partially with some of the supporters protesting that the criminal enterprise is not just R. Kelly alone. That is true. However, you kill the head, you kill the body. In this case, R. Kelly, he was the mastermind. He had not only the fame, the fortune, the celebrity, but he also had control. So R. Kelly's participation in hearing the testimony, it appears that these witnesses came off credible. I'm curious to see how the cross-examination of these witnesses went as well.
All right, Julia Janae, Court TV legal correspondent. An assistant, a former assistant of R. Kelly, someone from the inside, from in his world, also testified, Diana Copeland. What did she testify to?
Well, Diana Copeland was on the stand 2 days. Today was her last day of direct and then fully on cross-examination, and she told this jury that there were strict, stringent rules that the defendant had for his female guests, for his girlfriends, that one of them was, that she was actually fined for, was calling Ubers to help pick them up, that they had to be female, not male. If a male showed up, whoever arranged that ride would get in trouble. She also talked about a letter that the defendant asked her to write, saying that his lawyers wanted her to write it. And here's a bit from that letter. She wrote, "Dear Robert, this is the hardest letter to write. I have stolen money from you. I'm truly disappointed in myself and ashamed. You are a forgiving person. You're giving and loving. I don't feel that I deserve your love. I will never betray you again, and I love you." And then after that letter was read in court, the prosecutor asked, just to be clear, "Did you ever steal anything from the defendant?" And the witness said, no, this was not something that she had actually done. It was something that he asked her to do. Now, on cross-examination, they were able to ask her about those Uber rides, saying that this was actually a security measure to make sure that only female drivers were around the girlfriends. And the defense attorney, Deborah O'Canick, he asked, wasn't there certain language from the prosecution, as in Kelly said that he directed you or commanded something to happen? Is that actually your words or the prosecutor's words? And the witness, Copeland, she said that she adopted that language that they used, but that the prosecutors didn't suggest what she should use. But she did agree that this defendant was a loving person who was very generous, and that even having her write that letter, she said, came after a misunderstanding where they had separated the employment relationship, and she was trying to come back, and that misunderstanding was never resolved, but this letter helped to resolve things. So she ultimately seemed to be a neutral witness in the way that she testified on direct and on cross-examination.
All right, Julia Janae in Brooklyn, New York tonight. A lot more still ahead in that case. We'll continue to follow it. We'll talk to Julia a little bit later in the show. Right now, though, let's take you out to Akron, Ohio. Court TV crime and justice reporter Joy Lim Nakern is there for more tonight. In the other case we're covering here on Court TV, the death penalty case of Ohio versus Stanley Ford.
A forensic examiner walked the jury through a timeline of activity in the defendant's neighborhood the morning of May 15th of 2017, when that second deadly house fire killed a family of 7. Bradley Barkhurst spent hours on the witness stand describing the timeline he pieced together from home security records, 911 calls, and a neighbor's surveillance video. Prosecutors claim Stanley Ford is a shadowy figure seen running back and forth between his property and 693 Fulton Street, the site of the house fire that killed Angie Boggs, David Huggins, and their 5 children. Records suggest the alarm in Ford's home at 1374 Hillcrest was disarmed at 2:27 a.m. About 10 minutes later, the video shows someone walking from the area of Ford's home towards 693 Fulton Street, then running back. Minutes later, at 2:43 a.m., victim Angie Boggs tried unsuccessfully to call 911. The next 911 calls came in minutes later.
Hello? Hi, this is Secretary 911. We got a call from your number. Yes, it's a house on fire. I smell the gas. I need the smoke from a house on Gilford Street. Okay, what's the address of the fire? I don't know. It's almost gone. The whole house is almost burnt up. I just looked out my window from the corner. I walked to the corner. The house is on fire. It's almost gone.
Ford claims he had nothing to do with the fires. His lawyers did not cross-examine Barkhurst after challenging the reliability of the surveillance videos earlier in the day through witness Brian French, a forensic analyst with Akron Police.
We know the hash value of the copy does not match the original, correct? Correct. And we know that that means that the copy is not an identical copy of the original, correct? Correct. We don't know in what shape or form the difference is, correct?
I'm not sure what your question is.
We don't know how the copy is different from the original.
Correct.
The state could rest as early as Tuesday after calling a medical examiner and the lead detective in the investigation into that deadly 2017 fire. Back to you.
Joy Lim Nakrin in Akron, Ohio. Our coverage of that will continue. Again, big week coming up here on Court TV. We've got a lot more still ahead.
On the docket tonight in El Paso County, Colorado, Leticia Stauch accused of the brutal murder of her stepson Gannon, who was shot in the jaw and stabbed 18 times. Stauch back in court as the judge listens to the evidence in her preliminary hearing.
Stauch decided to waive her right to be present for the hearing, meaning she didn't get to see exactly what happened in the courtroom.
Plus, in Houston, Texas, a woman spots a peeping Tom outside of her bedroom at 11 o'clock at night. She grabs her rifle and shoots him through the wall, killing him. Is that a justifiable homicide? Go to our Facebook pages and tell us what you think.
On the docket tonight, the case against Leticia Stauch, the so-called evil stepmother accused of the murder of little Gannon Stauch. Our affiliate KOAA and reporter Colette Bordelon has the latest in her case as she faces a preliminary hearing.
Thursday was Leticia Stauch's preliminary hearing, where prosecutors have to prove to the judge they have enough evidence to take the case to trial. The results of the autopsy of Gannon Stauch's body, which was found under a bridge in a suitcase in the Florida Panhandle, were finally made public. The official cause of death ruled as a gunshot wound and blunt force trauma to the head. A bullet was recovered from his skull, which was also fractured, and his body had 18 sharp force wounds. An FBI agent confirmed the bullet found in Gannon's head was from a gun located in Stauch's bedroom, which also had her DNA on it. The prosecution says based on GPS tracking that Stauch drove Gannon's body to Florida with her teenage daughter in tow before the two went to South Carolina. We also watched the body-worn camera footage from the night deputies responded to the Stauch home in Lorson Ranch when Gannon was first reported missing. In it, we see a deputy look through Stauch's car in the garage, but he doesn't find anything. The arrest affidavit claims that's where she hid Gannon's body. A few days later, investigators found a trail of blood throughout the home originating from Gannon's bedroom. And in an unusual move, Stauch decided to waive her right to be present for the hearing, meaning she didn't get to see exactly what happened in the courtroom.
I don't blame her. Nothing good happened for her inside that courtroom. Let's bring back in our think tank, KC Early, Jennifer Brandt, Michael Bixon. Michael, I'm listening to this evidence, and I know there have been many search warrants, thousands of pages of documents, but now putting this stuff together, to me, the gun with the defendant's DNA in her bedroom and then tracking the GPS all the way from Colorado down to Florida near the Panhandle where little Gannon's body was disposed of. This is devastating evidence.
Absolutely. I think one of the hardest things to get around is the GPS evidence. And you see this a lot more in, the cases that we see nowadays with GPS tracking, cell phone tracking, and things like that. And obviously, if you're not doing a motion to suppress and there's not a warrant issue, they're very, very, very difficult to get around because it shows exactly where they went and what they were doing. And, on top of that, when you have things like guns and, other physical evidence, it makes it that much worse. So for the defense, they are going to have quite a struggle to get around something like this.
And KC, the other thing is Leticia Stauch, when she was first interviewed, first she reports him missing, that he went to his friend's house and never came back. Then she changed the story that there was some Hispanic guy, I forgot what his name was, because he doesn't exist in the real world. Anyway, came into the house and held him at gunpoint and raped her and murdered him. All of this stuff, bizarre stuff. Now they're tracking her. They're able to track her to where the body was where little Gannon was left, all the way in Florida. Let me ask you, though, about the teenage daughter. What, if anything, do you think prosecutors will do with her? Do they call her as a witness? What do they do?
Of course, you would think that the prosecution would call the daughter as a witness, but in this case, you're putting her in a difficult position to testify against her mother. And what additional information would she provide? In this case, the prosecution has overwhelming evidence. Put aside the GPS information. They also have DNA, blood on the gun And you also have this crime of passion, multiple stab wounds, as well as close range. So we know that the victim obviously knew the person who committed this crime, and the crime of passion. So there's overwhelming evidence. The prosecution is going to basically have to decide whether or not it's necessary to have the daughter testify in this case.
Jennifer Brandt, some of the other disturbing parts of this case, when he gets to what was happening, it seems that this evil stepmother felt like she wasn't getting enough attention from Gannon's dad, and he was just using her to watch the child. And I mean, sick stuff. Whatever's going on in her mind. You don't like the marriage, you just leave, right? I mean, that's what you do all the time. Family law. You don't like the marriage, you leave.
That's right, but you know it's a very emotional issue, and people get upset, and she was beyond upset, you know, with whatever was going on in the marriage, and in some twisted way perhaps thought that getting rid of her husband's son would help the situation. I can't imagine, but you know, in her mind, she was looking up things on the internet of, you know, about, you know, that she didn't want to be a stepmom and things of that nature. So, I mean, clearly she saw the child as a problem and didn't really look at the relationship itself. You know, unfortunately now you have this poor child, this poor victim, and, you know, and she's looking to spend a long time in jail, if not the rest of her life. So, I mean, yeah, it was obviously she's very sick to think about something like this.
And Gannon's dad is just, I mean, he's broken. He's broken.
Of course.
I mean, it's awful.
Yeah,
and,
awful.
And not his fault. I mean, he did nothing wrong. Okay, let's take a look. We've got no trial date yet. They're just finishing the preliminary hearing. That's the step. You get enough evidence. The judge says there's enough evidence. You go ahead to trial, then you set the date. So we'll keep an eye on this one for you out of Colorado. When we come back, everyone's talking about this story out of Texas. A woman is home alone. It's around 11 o'clock at night. There's some guy creeping around outside, a peeping Tom. She gets really scared, grabs her rifle, shoots him through the wall. He dies. My question to you tonight, is that justifiable homicide? Is that proper self-defense? Your verdict when we return. A lot of arguments today on my Facebook page talking about this story out of Houston, Texas. A woman is home alone, notices a guy creeping around outside, a peeping Tom. It's 11 o'clock. She gets really scared, grabs her gun, shoots, and kills him. And now authorities are determining whether or not there will be any charges in this case. So I put it up on my Facebook page, Vinnie Politan Court TV, asked you. What do you think? Is this justifiable homicide? Is this proper self-defense, or should she be charged? We begin with Carrie and our 13th juror comment of the day. Why can't a woman protect herself from a predator? Are we supposed to wait for rape and possible murder? How would you feel if it was your young daughter? Justified 100%. Kesia Early, justifiable homicide?
Not at all. Where's the fear? She was inside of her home. I understand that she says it's a peeping Tom, but who's to say he wasn't taking a late night jog or walking his dog or finding something? But absolutely not. She was perfectly safe in her home. This was not justified at all.
Ted tonight. Nope, not justifiable whatsoever. There was a wall and a locked door between them, and he was fleeing. She's going to jail. Michael Bixon, think she's going to jail?
There's a strong likelihood. Self-defense laws vary wildly from state to state, but if he had no weapon, he wasn't trying to force his way inside, he's just outside looking in, that's going to be a very tough one. I'm inclined to say that they will end up pressing charges.
All right, Rochelle tonight. He was trespassing with ill intent. Yes, this is justified. Every woman should be properly trained to protect themselves. How did she know he was going to just peep? Most of these peeping Toms end up being predators. Jennifer Brandt, how do you see this one, right? She's home, he's outside, he's not where he's supposed to be, she is where she is supposed to be.
Definitely creepy, but I don't know if it means take out a gun and shoot him. Why didn't she pick up the phone and call the police? Why didn't, did she turn on the outside lights? Did she do anything before she just took up her rifle and started shooting through the wall? I think she went a little bit far. First thing I would have done, call the police. See if she can get some help out there before she takes matters into her own hands.
Sue tonight, according to Texas law and the Castle Doctrine, she was in the wrong unless he was trying to enter her home. I think she will have a problem claiming self-defense. Well, Kesia, how is a jury going to see it if she's charged and if she goes to trial when she gets up there and explains what's going on in her mind at that moment?
Even if she explains it away, this would open the door for so many other cases where people just start shooting through their doors because they feel that someone is outside. This is a trespass. It does not warrant a homicide. And in addition to that, what if someone else was shot inadvertently? So this is definitely a homicide, and it was not justified.
Brenda, of course, she should have waited until he kicked the door in and had his hands around her throat. Sarcasm, Michael Bixon. You can understand Brenda's thoughts here. What, do I have to wait to be attacked here?
No, absolutely not. But that doesn't mean that
When can she start
shooting outside the
shooting?
house.
When can she start
If
shooting?
they are actually kicking in the door, if they are forcing entry into the home, if there is some actual reasonable threat, then sure, she can use reasonable self-defense. But she should have called the police. It's that simple.
All right. Michael Bixon saying wait till the door gets kicked in and then you have a right. No, but you have a right
Or
at that point.
Or at least if they're attempting forced entry. If they're
Okay,
attempting
but I
forced
mean at
entry,
that point,
still
then the castle doctrine kicks in. You are protecting your castle where you are rightfully
maybe,
are.
depending on the state.
Depending on the state. Texas, yes, they have the castle doctrine. Okay. Okay, see you early. Jennifer Brandt, Michael Bixon, awesome as always. We'll see you.